If you're a domain name investor, you likely have some phenomenal domain names that have yet to be developed. And if you're a great developer, you're likely looking for an opportunity for your blood, sweat, and tears to make a real difference in a venture that you directly benefit from. Those are the makings for a successful joint venture. In this show, you'll learn about many of the critical aspects when forming a joint venture. Stay tuned. I have 3 short sponsor messages before we get into today's show. First, if you have a great domain name and nothing to show when people visit, you're missing out on potential advertising revenue, leads, and partnership opportunities. NicheWebsites.com can build you a site quickly with a price option to suit any need. But as their tagline says, they don't just build websites, they build businesses. Second, if you're buying or selling a domain name or a portfolio and you want an estimate of its value, Estimate.com is the place to go. Just like you'd visit Zillow.com to get an estimate of a house value, Estimate.com provides key information about the most important statistics so you can make an informed decision based on data. Finally, DNX.com is a domain name exchange that uses a reverse auction platform to provide fair market prices for quality domain names that are manually filtered by an experienced broker. At DNX.com, domain prices drop until someone decides the price is right. But don't wait too long or the domain you love might be purchased by someone else. All 3 sponsors have a clickable banner in the upper right-hand corner of DomainSherpa.com. Here's your program. Hey everyone, my name is Michael Seiger and I'm the publisher of DomainSherpa.com, the website where you come to learn how to become a successful domain name investor and entrepreneur directly from the experts. Every conference I go to, I meet successful domain name investors who have phenomenal single-word domain names that define an industry, a product, or a service, but don't have the expertise or the time to build the business themselves. What they need is a phenomenal developer, one that can take an idea, process map the whole business, and then code it up to make it a reality. Those are the makings of a successful joint venture. But each side is understandably tentative about forming a legal relationship. What are the proper milestones, the metrics? What thresholds should you have to make sure that everybody's holding up their part of the bargain? How do you ensure that the assets and contributions that you're providing to this venture aren't a waste? That's what we're going to answer on today's show. And I'm pleased to welcome today's Sherpa, Zak Muscovitch, an internet and IP lawyer at the Muscovitch Law Firm. Zak, welcome to the show.
Thanks for having me. It's a thrill to be here, and I'm so glad to be counted as a domain Sherpa with your other distinguished guests.
Well, let's see how you do on answering some questions, Zak.
Okay, give it a shot.
All right, it's great to have you here. I want to start by saying that this show is not specific legal advice for you, the audience. It's not comprehensive. It doesn't address the specific needs that you have for any joint venture going forward. You need to seek the legal advice of an attorney that specializes in IP and domain name law. But this show should provide general information about the topic, which I've often wondered about. So let's start with a basic question, Zak. What is a joint venture?
Sure. Well, a joint venture can take many forms, but within the context of domain development, it generally involves 2 parties. One party that contributes the domain names to the joint venture, and another party that contributes the effort and the expertise to the joint venture. And when both 2 parties get together and each contribute either the domain names, the time, and the expertise, that together is what we call a domain name development joint venture.
Okay. And so that's one type of joint venture. How is that different than, say, a partnership?
Sure. Well, joint venture is a seemingly complex term, but it really is nothing more than a form of partnership.
Okay.
Both terms can be interchangeable within some contexts. But the way we use joint venture for domain name development generally infers a certain kind of a structure where the parties don't necessarily become formal partners on day one, and they don't share in all the assets necessarily as partners would. Rather, it's an incremental approach where the parties both start off at a certain point and then end up potentially partners or shareholders within a corporation.
Okay, so that makes sense. So a partnership sort of it makes people feel like there's some sort of joint ownership from the beginning. Maybe it's 50-50, maybe it's 80-20, but like starting off from day one, they're partners on a venture. Whereas a joint venture, it may not start out as a partnership, but hopefully it will end as some sort of partnership if things go well.
Exactly.
Oh, perfect. Okay. All right. Now, Rick Schwartz had started a venture or an idea, I'm not sure what to call it, in the past called jointventures.com, where he was trying to take great domain name assets and then find people to lease those assets. He called it joint ventures, but is a lease, like if I have a domain name and I just lease it for $100 a month or $1,000 a month, is that a joint venture?
Yeah, well, I actually had the pleasure of watching you interview Rick Schwartz on the joint ventures topic. And yes, a leasing arrangement is a kind of a joint venture. It's not the first kind of or structure of joint venture that would come to my mind, but joint venture is a very loose term and it can encompass a leasing type arrangement as well. Basically, within that context, it's any business arrangement where both parties are contributing something to an objective.
Okay. And if we zoom out of the process up to sort of the 30,000 foot level, we have on one hand an investor who has an asset, a domain name. And on the other hand, we have someone who can add value to that domain name. Maybe it's developing, maybe it's marketing, or some other service that they can provide. What are the typical stages to forming a joint venture, starting with, we just met at a conference and ending with, we have a legal agreement? How do you get from point A to point B?
Right. Well, I mean, there's from a high level perspective, there's really two approaches. The first approach is, let's say I met you at a conference and we had a coffee and we discussed your domain names, I had development expertise, and you gave me access to your domain name server and I started developing it, and then we shared profits, and that's it. That's the first approach, very informal. Nothing's more than that's required, and that's considered a joint venture. The approach that people come to me for as a lawyer, specializes in domain names and internet law, is to formalize that, document it, and provide some advice on specific issues that I've seen in my experience that arise that protect the interests of both parties. So really the first stage is, generally speaking, when two people, a domainer and a developer, get together and have a meeting of the minds where they agree to proceed on a project that could involve a single domain name or a whole portfolio of domain names.
Mm-hmm. Okay. And so if you're the developer and I'm the domain owner, we get together, we have a conversation, then maybe we document the conversation in email so that we both can look at what we talked about. But when it's in writing, maybe it means something different than, maybe it's a little bit more formal than what you and I just talked about. How do we go from an email? What are the general steps? And we'll get into the detail, but what are the general framework steps to go from that conversation and then email to a legal document?
Well, I'm always very happy when I get involved at that stage, when the two parties have exchanged emails and come to a meeting of the minds about the general terms or the general parameters of their project. And then they could say, okay, these are the general ingredients, Zach. Can you take it from there and talk to us about the other issues that you see, some of the considerations maybe we haven't thought of? And then could you put it into a document and recommend a structure for us to go forward? And so it's very helpful when the parties put in writing, even if it's in basic form, the general ingredients of a joint venture.
Okay, so conversation, then an email, then involve maybe an attorney, a lawyer at that time, and then you can take it and put it into a term sheet and work through any other additional issues that you've seen in the past. And that's an important thing. I know that I've never done a joint venture, so I don't even know what kinds of issues I should bring into a legal document. But you've done this a number of times, so you can help guide the conversation around, have you discussed A, B, C? And then eventually you end up at a legal document.
Sure, and that raises two other possibilities. One is that sophisticated or experienced joint ventures might develop a term sheet on their own and present it to me and ask me to further document it in a contract or set of agreements. The other thing is that one or both the parties can come to a domain name lawyer and that lawyer can create a term sheet with them in consultation with them. And a term sheet is a really great document because what it does is it essentially lists all the terms, all the deal points, otherwise known as deal points, that will eventually go into a contract. Because it's always best to sort out and agree upon the basic terms in a term sheet or set of deal points prior to incorporating it into a much longer, more comprehensive agreement.
Yeah. Now that's a cool point that you bring up, Zach, because you've done this a number of times before. How many times have you put together a joint venture type deal in the past?
Right. Well, I've been practicing domain name law for about 14 years, I'm shocked to say. And these kinds of joint ventures come up with regularity and increasing regularity due to changes in the domain name market, which maybe we'll talk about as well. But basically, I do this on a daily basis. There's always an agreement that I'm doing, whether it's a formal joint venture, shareholders agreement, something involving a business relationship between two or more parties regarding development of websites.
Yeah. And so I like the idea of involving somebody who has experience in a joint venture early in the process. But my hesitation to doing that, Zach, is if I was, thinking about using you as my attorney, representing my interests, sort of like a real estate broker representing my sale interests, I wouldn't necessarily want you to be involved in the other party's interests in the term sheet, because you may bring up something that's more beneficial for them and less beneficial for me. How do you resolve something like that when somebody asks you to be involved early in the terms?
Right. Well, that's a very good and important issue. And generally speaking, I only like to work for one party. It makes my duties and obligations a lot clearer, and I'm able to provide better service to one party. On rare occasions, two parties will come to me and ask me to prepare documentation based upon agreements they've reached. And in every such case, they'll have to seek independent legal advice because I'm just not able to counsel two parties on the same deals effectively.
Right. Okay, that makes sense. So I want to take a moment, Zach, and ask you a few questions about you personally. You mentioned that you had been in legal profession, practicing law for 14 years, done a number of joint ventures. Back when I first introduced you on the show, I put the little title up that said Zak Muscovitch, dnattorney.com. And of course, all of the domain name investors are thinking, great domain name, Zach. When did you actually acquire the killer domain name dnattorney.com?
I've never been asked that question, but I actually have an interesting answer to that. It's been, I forget the exact number of years, maybe about 8 or 9 years perhaps since I got it. And it was actually given to me because I helped a client with a domain name issue, if I recall correctly. And out of the goodness of his heart, he thought I should have this domain name and transferred it to me.
That is very nice.
At the time, I didn't fully appreciate what a great domain name it was, but it's really grown with me, and so I'm proud to have dnattorney.com now.
Boy, it's a good thing you didn't let that drop in the middle years where like, hey, how much is a domain name worth? I interview people all the time that talk about that.
Yeah, those periods are scary in hindsight. Yes.
Do you own an investment portfolio of domain names yourself?
No, my interest in domain names purely as a professional. I've dabbled in registering domain names, but I haven't been as successful as most of your viewers. I started getting into the internet and internet law back in 1996, and I'm embarrassed to say the names of a few of the domain names I thought would have value back at that time. I think I registered robotfishing.com and robothunting.com. I thought it'd be the next big thing. Boy, was I wrong.
Now, if you had only gotten robot cars, then, Google might have wanted to buy that off you. I hear that cars are actually driving around the Bay Area unencumbered by people controlling them to shuttle employees between locations. It's unbelievable.
That's right. Well, listen, the reason I got into internet law is because I'm very excited about technology and I love new technologies and I always have. So those kinds of stories are of great interest.
Yeah. And I'm sure some of my audience is going to wonder, you have an accent. It doesn't sound like you're from Texas.
Right. Well, I could ask you the same thing. But,
I am definitely not from Texas.
yeah, well, I guess nobody ever hears their own accent. But to give you some background, I'm from Toronto. I live and work in Toronto, and I'm privileged to have clients all over Canada, but also all over the world, because as you know, domain names and domain investing, domain business is very much international.
Definitely. And are you able to draft and execute legal documents for parties in the United States and Russia and Europe, even though you're located in Canada?
Well, typically the deals that I work on that involve buyers, sellers, lessors, lessees, these are international agreements. Mm-hmm. And so, yes, I do get involved in those kinds of agreements. But if there's an issue that involves local law, then we consult with a local attorney who's able to provide that jurisdiction-specific advice.
Okay. All right. So let's take an example of a domain name owner and developer coming together to form a joint venture. For any agreement to be made between the two parties, you need to make sure you have a verbal agreement to the terms of the venture. You sent me a term sheet with 36 items identified. It was a fantastic term sheet that allowed me to sort of think through my thought process around the questions that I wanted to ask you. As I mentioned earlier, this is not a show that's intended to provide specific advice to any person that's watching the show. And it's not fully comprehensive, and people need to consult an attorney in order to have all of their legal rights represented properly. But Zak, I thought this was a great area. We're only going to be able to tackle in the hour or so a few of the items and dig into them. Would you mind if I posted all 36 items below this show for people to take a look at and make sure that they are thinking through all the appropriate aspects of a joint venture going forward?
Absolutely. And of course, your viewers should be aware that this is not tailored to their specific situation. It's not right. Comprehensive. It's just an example, some of the kinds of terms that may be considerable for a particular joint venture.
Cool. All right. So I'm going to ask you about a few of them. Domain name owner and contact information is clear from the list that I have here. You want to make sure that you get the legal entity or the person's name and the address and communication channels clearly identified in agreement so that you know how to serve notices or what have you. Developer name and contact information is clear. Let's talk about the term of the agreement. What does term mean, and what is a typical term for a joint venture agreement?
Okay, well, that's a confusing term, actually, because it has a couple different meanings depending on the context. And so terms can mean the points, aspects of a deal. So when we talk about the terms of an agreement, we're talking about the aspects of it, or points of it, so to speak. But term with a capital T in most contexts within a joint venture agreement refers to the duration of the agreement. So, for example, a term could be agreed upon to be 5 years, or it could be 2 years, or it could be various stages and go through evolutions over the course of a term. So that's what term means within this context.
Okay, so if we talk about term duration, and we'll get into the terms, the individual details of the agreement, but later. But we'll talk about just the duration right now. What is a typical duration that you've seen? How long does a joint venture need to be up and running in order to figure out if it's working or not?
Right. Well, most joint ventures approach a particular joint venture with the intention that it will be an indefinite relationship between the domain owner and the developer. And so we go in with that expectation. But that doesn't necessarily mean the term is going to be indefinite, because what we want to do is insert some safeguards so that we have kind of a getting to know you period, probationary period, where the parties can see if they work together and the parties can see whether they produce results. So generally speaking, we try to create at the front end of this term a fixed period that has certain thresholds that have to be met, particularly by the domain developer. So, for example, we could say, Michael, you're going to contribute the domain name abc.com to this joint venture. And me, Zach, I'm going to contribute the development expertise. And you say, well, that sounds great, but I mean, I don't want to tie up my domain name for 5 years or 2 years or indefinitely unless I see that you're really producing results. And for me, results means revenue or at least increased traffic. And it's got to be better than what I'm doing on my own. Otherwise, I want to be able to pull back this domain from the joint venture. And so depending on the nature of the business and the nature of the website, we'll select a term. So it could be, if it's a very sophisticated project that we know is going to take a year to ramp up and create text and get content together, maybe there'll be a year just at the very beginning where we don't even expect any results, and then another year or two after where we are expecting results. So it really depends on how sophisticated the project is and how much work is involved.
Yeah, great point. So I want to reiterate that a joint venture is a long-term partnership, that hopefully the parties will become some sort of partners in the process, that is the intended expectation of forming a joint venture. It's not, all right, I'll give you a trial period, and if you can make this work, then let's talk about it. It's actually forming a long-term relationship between two or more parties.
Sure. And you know what? That raises the important point about, what is the objective at the end of the joint venture? Because we talked about how there's an expectation of being indefinite, but it can take two different forms, Michael. So, for example, some developer, he might be just happy, and we'll talk about this more, about getting a share of the revenues, the profits from the joint venture. But another one won't be happy with that. He'll actually want to take an ownership share eventually in this domain name. And so that's really the ultimate goal, is for them to either share in revenues or become joint owners in the domain.
Right. And that's a great point. And any joint venture is going to have different objectives. For example, if you think that, like an Amazon, you just build it, and regardless of whether you make any money, if you get more people coming to your website and using your services, then eventually you'll be able to monetize it. So you may have a goal that 2 years, you just want 100,000 or 1 million people coming per month. And for that, you're willing to share in the value of the domain name or the whole business, then that's fine. It doesn't, so the threshold of that probation period that you talk about doesn't necessarily have to be just monetary, just revenue or profits coming in. It could be some other metric that both parties find valuable.
Yes, absolutely. And the parties will generally know best what their expectations are. It could be, as you point out, a certain level of traffic, could be a certain level of revenue. Generally, those are the two categories that are more tangible that we like to set thresholds for.
Definitely. So right under the term of the agreement, you have stages listed. What are the different stages?
Right. Okay, so at the beginning, we spoke a little bit about how the difference between a joint venture and partnership could be that a partnership, people really expect to be partners day one in certain assets or in a certain business, whereas a joint venture doesn't necessarily have to be that way, because each party is contributing something different, or each contributing something, period. So the stages are crucial in joint venture, and let me explain why. Once again, let's say you were contributing a domain name abc.com to this joint venture, and I was contributing the expertise in developing it. And you could have gone and hired a developer such as me, and you would have had to pay that developer. But you've chosen not to do that. Your reason could be to free up cash flow for other projects. It could be because in order to get someone as qualified as myself, you need to offer more than an hourly rate or fees. You needed to give the guy a piece of the action. And so when we get together for this joint venture, you're contributing the domain name, I'm contributing the expertise, but I'm going to want something more from you, Michael. Will you give me a share of the domain name? And you'd be like, well, listen, I don't have a problem with that in principle. I would love for this to be so successful that I'm getting a lot more revenue in than before we were working together. But I'm not about to give you a share of my domain name on day one, because we've just met, or we're just starting to work together. So how about you earn up to that point? And so the first stage really should be a trial period where you're testing whether this arrangement works. You're trying to see whether by involving me in the development of your domain name, you're able to realize greater traffic, greater profits. And if that's the case, then you might say, you know what, things are going on the right track. Once you know they're going on the right track, Michael, then you're able to say, okay, you've earned 10% of this domain name, you've earned 25%, all the way up possibly to 50% of the domain name. And then we're back to being partners, as we talked about before. And that really will change depending on the value of the domain. If we're talking about a $10 million domain name, a month of great work by me isn't going to earn me 10% probably, but it could. Depends on the situation.
Right. Okay. So basically 2 stages. There's the trial stage to make sure that the domain owner has the domain. They're contributing the domain. So that's pretty much decided right there. But the developer needs to prove that he or she can contribute an equal asset or some sort of benefits to the joint venture. And then once you pass the trial period, then you move into, an earned percentage, some sort of earned partnership in the joint venture. So I'm sure people that are watching the show are going to say, well, how do you determine what percentage you own and how do you figure that out? If I have a domain name, I may think it's worth $100,000, but if I try to liquidate it today in the, domain name aftermarket, it may only be worth $15,000 or $20,000. I have to wait like Rick Schwartz for 10 years to get that 6-figure payday on that domain name. So, we may have a difference in just the valuation of the domain name. And then, the developer may show up and say, well, my hourly rate is $200 when I bill out as a contractor. But, so how do you bring these competing, or not competing, how do you bring these 2 parties together who have potentially inflated views of what their assets that they're contributing to the joint venture are?
Yeah, well, it's at that stage of negotiation where many potential joint ventures could very well break down because the domain owner thinks he's sitting on a diamond mine with this domain name, and the developer says that it's worth absolutely nothing without it being developed or next to none. So often this is where joint ventures can falter even before they begin. But there's a few different approaches that people have found work in terms of how to value each party's contribution. As you know, domain names are notoriously hard to value in any empirical way. One of the only ways of genuinely valuing a domain name is if, for example, the domain owner had recently acquired the domain name and paid X dollars for it, right before the joint venture, then we know how much the domain is worth, more or less, right? And so it could be that, let's say the domain is worth $100 on that day. And then we set a threshold for earning $1 a month for the joint venture. And once we hit $1 a month, then we start doling out interest in the domain name. We could say that if you paid $100 for the domain name, in order to earn 50% of it, you would have to earn $50 as your share of the profits. So once we earned $100 on this domain name, then theoretically I could have earned my 50%. That's one approach. Another approach, which is probably more common because not very often someone has just acquired a domain name prior to entering into a joint venture, is for the domain owner to say, look, the reason I'm even contemplating a joint venture is because I've been sitting on this domain name, which is potentially terrific, but because I'm committed to other projects, because I don't have the expertise, it's just not earning me much money, but it is earning me something, okay? So if you're only through your development efforts able to earn me the same, well, you've earned zero for me, right? But anything in excess of that, well, that's something that we could talk about because that's better than how I'm doing now. And so I'll credit you 50% of that incremental increase that you're providing through your efforts and credit that towards an interest and ownership in the domain name. That's a more common.
Great. And so the domain owner might also say, I'm earning $2 a month in parking. And so any revenue above that threshold, I'll credit you towards some ownership aspect as well.
Precisely. A portion of that because the domain owner wants to get credit for that too,
Right.
because he's contributing something, but that's precisely the general approach.
Great. Okay, that makes sense. Another one of the terms is escrow of the domain name, Zach. Why is escrow a good idea or a bad idea?
Okay, this is an interesting dynamic that kind of exemplifies the general kind of frictions in a joint venture agreement between a domain name owner and a domain name developer. And the domain name owner says, "Okay, that's great. We're going to work together. I'm going to give you access to the DNS. You're going to start working like a beaver, creating this fabulous. Say we're all going to make lots of money. Okay." And the domain developer says, "But hold on a second. I'm the one that's working, slaving away, developing this thing. And how do I know that I'm going to get my share of the ownership at the end of this? Suppose you leave town, suppose you sell the domain name in the interim, I'm left with nothing." And so the domain owner says, "Okay, well, I'm not about to, give you your share now on day one. So how about this? How about we approach a third party, an escrow agent? It could be an attorney or it could be a commercial outfit like escrow.com. And we place the domain name in there for this reason. We want to provide some security for the domain name developer that if the developer complies with its obligations, performs, there will be the domain name available at the end to dole it out." And from the domain owner's perspective, he's not relinquishing complete control because it's sitting in a safe place, and he'll get it back if the obligations or thresholds haven't been met.
Okay, that makes sense. And one of the things you just mentioned was that the escrow could be at a service like escrow.com that we all know and many of us use, but it could be at an attorney. Like any attorney can serve as the escrow agent as well?
Absolutely. Essentially, an attorney would hold the domain name in trust, would prepare an escrow agreement or a so-called trust agreement, and that agreement would set out specific triggers for releasing the domain name back to the original domain owner or releasing it to a new entity to be jointly owned, for example, by the two parties.
Okay, and that's as simple as executing a simple document that says this law firm is holding this asset in trust for this agreement and references it all, just like what escrow.com does. But, like many of us online, when we have to go sign up for something, we probably don't read every single detail. You as an attorney or any intellectual property attorney would have an agreement that says those same terms, right?
That's right. Generally speaking, any attorney or commercial service that provides escrow service would have a quite comprehensive agreement. We just may not read it every time.
Gotcha. And the who is information on the domain name, if it's in trust with an attorney, would that change to say the attorney's business name and that it's in trust or?
Yeah, in most cases it would, and it would be important in most cases to do so because essentially by putting it into trust and having the who is details reflect the escrow agent's name rather than the original domain owner's name, you're letting the public know, whoever looks at the who is record, that this domain name isn't owned by the original domain owner freely and clearly anymore. It's in some kind of holding pen or it's subject to some kind of agreement. And therefore, if you were to try to buy it from the original owner and you check the who is, you would see, wait a second, the guy trying to sell it to me isn't the recorded person on who is. And so that's why we like to have it like that.
Makes sense. All right. Milestones and thresholds are often the most important terms to get agreement. The domain owner wants to see traction. They want to see results in some way, as we've discussed. Maybe it's monetary, maybe it's just traffic or signups or what have you. The developer likely wants more time in any case. It's probably infrequent where you set up your expectations and, they're met right off the bat. You never know how quickly search engines are going to index, how well they're going to index. There's a lot of different factors.
Absolutely.
How can the two competing issues be quantified fairly in agreement where the domain owner wants to see results and the domain developer wants more time?
Well, the beauty of the joint venture arrangement is that even though each party has their own competing interests, as you pointed out. They also have very similar interests. And for example, the domain owner likely wouldn't be interested in joining forces with the developer if he was doing well with the domain name, right? This is a great opportunity to finally get something going with the domain name, right?
Right.
He's eager to get the deal done. And the developer is like, when I contacted the guy, he wanted $10 million for the domain name, right? But so finally, I'm able to work on a real great domain name without any money down. So the parties have a lot going to get them to reach an agreement, and that's what drives it.
Gotcha. What are some customary development milestones and success metrics associated with a shared interest like that?
Right. Well, often the domain owner looks to the developer for cues in that respect, because it's really the developer who's coming to the relationship that says, I have the expertise, I've done this before, I know what I'm capable of, I know what tools are out there, I know what results are reasonable to produce. So the developer really is the one that pitches what he can provide in terms of revenue, traffic, signups, users, whatever it is. And it's important for the developer to be realistic, because the domain owner is going to say, okay, I like what I hear. Let's record that and make that the kind of threshold for this deal to keep going beyond that point. And on the other hand, a domain owner might say, what you're promising isn't good enough for me, and might say, I need you to, make it a little stronger, make your commitment a little higher. Because if I can't get this dollar or this number of traffic, it's just not worthwhile for me to get in bed with you like this.
Yeah, that makes perfect sense. Whenever I start a new venture myself, I always hope for the best and prepare for the worst. What if milestones and thresholds aren't met in sort of that trial period of the joint venture? Does the agreement fall apart automatically?
Right. Well, I wouldn't call it the agreement falling apart, because the agreement is designed and drafted with that contingency in mind. So in effect, the agreement works regardless of whether the project works, right?
Good point.
And so we would try to prepare an agreement that gave very specific instructions to each party, and possibly also the escrow agent, for what is supposed to happen if certain thresholds are met. And there could be a grace period, all right, because it's not like you missed it by $1 in a day and things should end right there. There's grace periods. Maybe there's secondary thresholds that if you don't meet this one, you don't get this percentage, but maybe you get a lesser percentage. There's incentives for increasing. So if those thresholds aren't met, and if the grace periods have elapsed, then generally speaking, if it's at the early stage of the joint venture, before there's been any ownership interest acquired by the developer, we would have the domain name revert back to the original domain name owner, and each party would go their separate ways. Often in that situation, there's still some intellectual property content that's being developed, even in that short interim period, and we'd have to address who has the rights to that. Often we have it so, well, you know what, this hasn't worked out. Domain owner gets their domain back, developer gets the content they created back, and the deal is terminated.
And that makes sense. Everybody, walks away from the agreement with the assets that they provided. Clearly the domain owner is only getting the domain name back, and the developer has put in some things that they can't tangibly take back: their time, their marketing efforts, links to the domain name, things like that. But if there was content written or technology coded up or things like that, they walk away with those technologies that maybe they can use in another business of theirs sometime in the future.
Sure. Or at least the developer's satisfied that the domain owner didn't get to keep them for that.
Right. So I understand, back to my earlier question where we talked about escrow, it makes perfect sense if, I use you as my attorney and you act as the escrow agent, so that if the agreement, I shouldn't say falls apart anymore, if the agreement comes to a conclusion where the thresholds in the trial period weren't exceeded or met, then you would know how to handle the domain name because you have executed the agreement. But what happens if I use a third-party escrow service? How do they know to release the domain name back to the registrant? I'm sure they don't want to get into the legal details of every single joint venture agreement out there.
Yeah, good question. So, generally speaking, it's preferable to have a truly independent third party act as escrow agent. In other words, not the attorney for either of the two parties. And the reason is that, although an attorney representing one party can, under some circumstances, act as an escrow agent, that party isn't entirely impartial, of course, because he has another duty to his client. So ideally, it should be a completely independent third party. Now, let's assume that it is that completely independent third party. The skill in drafting the escrow agreement and in the joint venture agreement, in part, is providing clear instructions about what's to happen. So there's no question about what the escrow agent's supposed to do and when. However, as with all things, disputes can arise. And if a dispute arises about whether the agreement truly was breached and whether the domain name should revert back to the original owner, well, generally speaking, an escrow agent would hold on to it until that dispute is resolved, either by the parties or by an order of the court.
And that makes perfect sense. But in the real world, I'm not sure how that would be executed, Zach. So let's say that I'm the domain owner.
Yes.
A year and a half, 2.5 years passes. The thresholds weren't exceeded in the agreement. Do I then notify the third party escrow company, hey, this agreement is no longer valid. Please release the domain name from escrow back to my name?
Okay, so right, generally speaking, you would, if you were the domain owner, first you notify the developer that, look, as we both know and discussed many times, this hasn't worked out, so the deal is going to be terminated. And then you would, ask him to confirm along with you to the escrow agent that the domain name can be released. That's a cooperative way of doing
it.
Okay. And that's generally speaking the way it would go. However, as I said, if there were a dispute where the domain owner informs the escrow agent, release the domain name to me, and the developer says, no, not so fast, then the escrow agent would just hold until this dispute was otherwise resolved.
Okay, that makes perfect sense. Now, to that point, if the parties don't agree, let's say that one of the thresholds was traffic, and I don't think that, as the domain owner, I don't think that we reached 100,000 unique visitors per month, but the developer provides some sort of information that says that it has, but it's questionable. What's the next step if there is a disagreement about whether certain thresholds were met in the agreement?
Okay, well, that would be a business dispute. Like any common business dispute, the parties could try to resolve it through negotiation and reach some kind of compromise or settlement of the issues that could involve them continuing to work together, or could involve termination of the agreement, or they could lawyer up and let the lawyers try to work it out amongst themselves. And if that doesn't work, then they can go to court. So it's no different than any other kind of business relationship that falters. There's various ways of dealing with it. And ultimately, you can go to court if you need to. Or often we use arbitration clauses. That sometimes it's more effective to use an independent commercial arbitrator to resolve the dispute.
Right. And, I've executed some agreements that is that middle step between, the parties negotiate and you lawyer up, you each get your own lawyers. There is that arbitration. And in a lot of cases, the agreements say you agree to an arbitration court located in a certain location that will have, one person review it, and you are bound by the decision of the arbitrator.
Yes.
And is that often a case? Do you do that in your agreements as well?
Very often we do. There's pros and cons for deciding to insert a clause that says that disputes are to be decided by courts or by arbitrators. Some people think that they prefer to have an arbitration clause rather than a court clause in an agreement because they think that it's faster and cheaper. It's not always the case, but the thinking is, at least, is that, we could, instead of having to wait for a long trial date, we could hire a former retired judge and get a trial date in 2 or 3 months, pay him a fee, and we could get this resolved much faster than many court systems.
Yeah. Okay. That makes sense. how do you make sure that you're entering a joint venture with someone who's not litigious, who is not going to go immediately to, a lawyer and try and fight you every step of the way, and you want somebody that's going to, be a partner, that's going to work with you, that's going to communicate well? How do you make sure, when you haven't met this person before and you're coming together, how do you make sure that you find somebody that's not litigious?
Well, I think that generally speaking, joint venture agreements are serious commitments by both sides, and I think for any kind of serious business commitment, you wouldn't just enter it into it with a stranger. You might be tempted to, but you would perform the normal due diligence you would on any person you intend to do business with. You might look to see about their past projects. You might speak to people they've worked with. You might, if you're really suspect of them, you'd see if they've been parties to any court cases and look up their name in the court databases.
Oh, so you can do that sort of thing.
Check, see if they've ever been in bankruptcies. You could Google them. You look up them in the social media, get a picture of who you're about to do business with. So those are the kinds of things that you would want to check before you do business with anybody.
Great points. All right. And clearly that's not a comprehensive due diligence checklist either, but that gives people an idea of what should be done prior to entering a legal agreement with somebody for long term. And again, this is an indefinite relationship that you're forming with the intention of. And so, things like that shouldn't be entered into willy-nilly or without any thought associated with it.
Absolutely, because we could go through endless precautions in terms of writing a great legal agreement, but ultimately it's the quality of the person you're doing business with which matters as much or more.
Definitely. Should the parties form a legal entity right from the beginning of the joint venture? In other words, should you form a C corporation or an LLC or one of the other entities, legal entities?
Yeah, the parties could. They could do that on day one, but generally speaking, I tend to recommend that they don't. And the reason is that it's easily done to incorporate a company, register a company, etc. But really, we don't need that company on day one because the domain is probably going to be put in escrow. And so we don't need the company for that. It's going to be with a third-party escrow agent. And the developer is going to be contributing its own time and effort. And once we incorporate and they become shareholders or members together on day one, it's a lot harder to extricate them. There's legal fees, there's paperwork to do. Why? Why do it on day one in most cases? So I tend to leave that to the stage where we actually are doling out an interest in the domain name. And it's crucial at that point because, as you know, a domain name can only be registered really to one person. And so we need to create an entity to own that domain name, and then we distribute shares in that entity in many cases.
Okay, and would you actually detail that in the joint venture agreement that when this trial period meets these thresholds, then shares in the domain name will be distributed through the formation of a legal entity, and sort of detail that much?
Precisely. We would use language very similar to what you just said, in fact.
Jeez, boy, when I start talking legalese, that's not a good sign, is it, Zach?
Pretty good. So we would say exactly that. We'd say, at this stage, we would incorporate this corporation. These persons would be the officers, the directors. These would be the shares issued on such and such a date, etc. Sometimes we do it that way. Other times, every deal is different. I've seen it done other ways where we issue the shares, we create a corporation, issue the shares on day one, but those shares are held in trust or in escrow pending the developer earning them.
Makes sense. I think one of the biggest fears of any developer joining into the venture is that they're meeting all of the thresholds and requirements of the agreement, but the owner suddenly receives an outrageous offer, a 6-figure when they thought the domain was valued at 5 figures, or 7-figure if the domain was valued at 6 figures. And the owner then wants to sell the domain name. From a developer perspective, they've invested a lot of time. Maybe they've got sunk costs that they could have been doing something else that was significant at the same time. How do you handle a situation where the owner wants to sell, but it's before thresholds are even considered for share distribution in the domain name?
Very, very tricky situation, because the domain owner, well, first we will start from the premise that, listen, the two parties have committed to each other. And so whatever they've committed to, they're stuck with, for better or for worse. So if the domain owner has committed to going along this development path with the developer and is committed to the possibility of the developer earning an ownership share of the domain names, the domain name owner can't sell on his own accord unilaterally at any price he wants, because he's bound by this pre-existing contract. Now, that being said, it's pretty hard for the domain owner not to want to go for a deal like that, right? And as much as he'd like to take all the money for himself, he's got to compensate the developer. And so what we tend to do is to say, look, Mr. Domain Owner, if you get an offer that's, over X dollars that obviously makes you very, very happy, you really want to take it, you're going to be so happy that you're going to compensate the developer too. And for the developer, that might be to some extent a windfall that he happened to go into a JV at the right time with the right domain, with the right guy. Everything's worked out. Maybe he's going to get more out of that than he deserves, considering the amount of time he's put in. Maybe not. Maybe the developer says, look, if I can get just 10% of the purchase price during the first 3 months, I'll be happy. If I've been working on it a year, maybe I need to get 15 or 20 to make it worthwhile. So we basically look at, at what point the number comes in. And if it's at a point where the developer hasn't earned any equity, usually the developer will still get a little taste of this deal as consideration for their efforts. If it's at a point where the developer has already earned equity, earned shares in the domain name, well, it might be that if he has 15% at that point in time, that's all he gets of the domain purchase, or maybe he receives some kind of increased amount or bonus for this happening on his watch.
And do you decide those percentages or what the bonuses are before you enter into this, or have you done some joint ventures where it's a negotiation in order to terminate the agreement early?
Well, generally speaking, it's good to have provisions in there which set out a formula for what happens with that contingency. I mean, it doesn't often happen that a domain is going to receives a great offer in mid-development in a joint venture. So it's not that it doesn't happen very often, but it's always preferable to have these things worked out at the beginning. At the end of the day, often these things are resolved through negotiation, because if there's enough money on the table, there's enough to go around to treat everybody fairly.
Yeah, good point. What if the website is meeting the requirements of the agreement? It's hitting, the thresholds that both parties agreed to before, but it appears like the developer is slacked off. It's growing, but the developer's not adding any new features or functionality or things like that. Is that a situation that you've seen where the domain owner is unhappy with the agreement, but the developer is saying, well, I'm happy because I don't have to do any more work and it's continuing to hit the requirements that we agreed to?
Well, generally speaking, it takes an active and vigorous developer to meet those thresholds. If that's not the case, that means the thresholds weren't ambitious or accurate enough to begin with. So you can often see a situation where thresholds are being met and the developer is leaning back on its laurels. It's more common, I think, to see a situation where they've entered into an agreement, often with the help of an attorney. The developer is not contributing to the project on a daily basis as he ought to have and as he promised. And the domain owner is saying, well, my domain name and website is dying on the vine. I could have gone in bed with another developer. I could have done anything else with this. And now I'm stuck with you and you're not doing everything. You're not working on this on a daily basis. So often we can include provisions in these agreements that require the lights to be on, so to speak, right? You got to be working on it X hours, or there's got to be constant improvement, things like that. And so we don't just allow people to sit on their laurels.
Yeah. All right. Great point. There's so many other provisions here that I'd like to ask you about, Zak, but I think you've done a great job providing an overview for what a joint venture is and the major aspects involved in the legal agreement of a joint venture. So here's the final question that I have for you before I wrap up with some final advice to readers. I've heard that you, as an attorney, have beat Google 3 times in UDRP cases. Which is to be congratulated, I think, because Google's a behemoth and they can probably afford more attorneys than they want or need. What were some of those domain names that you were able to successfully defend?
Well, that's right. Aside from doing internet and domain name related business deals, I've handled probably over 70 different UDRP cases and other different kinds of arbitrations and several precedent-setting court cases as well. And amongst those, I've managed to beat Google 3 times, 3 separate cases. Mm-hmm. If I recall correctly, one was Groovel.com, then came Goggle.com, and then Oogle.com. And so Google only had, I believe, 4 or 5 lawyers working on each case. It wasn't a fair fight.
And what was there one legal tactic that you used in all 3 cases, or was each one independent and required separate proof that it wasn't a case where the registrant was trying to take advantage of the brand that Google has created?
I use the same ingredients in every case: hard work, creativity, and passion. And those work every time. Been fortunate when we succeed in a case, but often, we go with the cards we've been dealt. So can't take the credit. It's also the facts that help win cases.
All right. I want to ask the audience, if you have additional questions, you can post them in the comments below this video, and I'll ask Zak to come back and answer as many as he can. Now, having said that, this is not a forum for personal legal advice. Zak cannot provide advice to everybody individually. He just doesn't have enough time, unfortunately, for us. In addition, we are not clients of Zak, so he can't legally provide any. I believe the board that you've agreed to follow, the ethics, doesn't allow you to provide legal advice unless somebody is a client of yours. Is that correct, Zak?
That's generally correct. I mean, everyone's welcome to reach me through dnattorney.com, by email, by chat, by telephone. I'm generally always available and happy to provide some general guidance. But in terms of asking specific questions about specific legal issues, that I'm afraid you need to be a client.
Okay, but general legal advice, if they have a question that, hey, Zak, in general terms, do I need to do this or that? Is that something that they can ask in the comments below?
Go ahead. I'm pretty good at giving the right kind of general answers.
All right, and if you can't answer it, then you'll just point, give me a call or contact me through dnattorney.com. All right. Zak Muscovitch, internet and IP lawyer at the Muscovitch Law Firm and dnattorney.com. Thank you for coming on the show, sharing your knowledge about joint ventures and forming long-term, indefinite relationships between 2 parties. And thanks for being a domain Sherpa.
Well, it's a real privilege and honor. It's such a thrill to be here with you. Thank you so much, Mike.
Thank you. Thank you all for watching. We'll see you next time.